Morning, ma'am. Are you Brittany
Good
Davis?
morning, yes.
And Miss Davis, did you get someone hired?
No, it's kind of expensive, but
Who'd
really
you,
expensive. I'm not even working right now. But I
who,
went through
who'd you talk to?
the legal aid. I put in an application for legal aid. It's a
Okay.
place that help you get a lawyer, but they say it could take 6 months to a year. So
Okay. So did you talk to any other lawyers like I told you to?
the first three that I talked to, wow, I talked to like probably 8 of them. But the lowest there goes like 2,000 to start off.
Do you have the names of the lawyers that I asked you that you talked to?
You asked me that last time. I was on.
Right. And then I reset you to talk to them more or get someone hired. So
I
did you
talked to
talk to
Brenshaw. I talked.
To
I
who?
can't remember their name. Brenshaw. There's one that's brothers.
Why wouldn't you write that down and bring it?
I wasn't expecting that I had to.
So it looks
I thought
like
I already.
you weren't what?
I wasn't expecting that I had to.
So if you're okay. If I tell you to go talk to some lawyers and bring me the names of the lawyers you've talked to, and you don't think you can remember them, then I would think just common sense would tell you to write them down so that you could tell me that you did what I ordered you to do so that you wouldn't go back to jail. Right?
I did do what you ordered me to do.
Okay.
The
So
first time,
I
I
ordered
didn't-
you to bring back the names as well, not just talk to them, but bring back who you talked to so that I know who you talked to and that you're doing what I asked you to do. Right?
The
Right?
cheapest ones that I've given you the last time I was here is the main ones that I was looking into.
Okay. But when you left last time, I gave you specific instructions,
Okay.
right?
Right.
Okay. So are you wearing your drug patch?
Yes, ma'am.
So it looks like back on. Second. So you tested positive since you've had that drug patch on for methamphetamine.
What is that?
What does that mean?
I don't. But what with the patch?
Mm-hmm. Looks like you tested positive for methamphetamine, cocaine, and cocaine.
Uh,
Hold on. Let me print it out so I can read it better. So last time you were in here, you had an issue because you had showed up with your drug patch in your hand, so they couldn't test it. So I tested you in court, and then I made you get the drug patch put on again and told you to keep it on. And then the drug patch that was put on January 25th. Which was the day before that court date. So you had one on, you had taken it in, you put it on, tested positive for methamphetamine and cocaine. Have a seat in the jury box. I'm going to have you tested this morning and then I'll decide what to do. Thanks. Actually, come on, ma'am, come on back up here. I know what I'm going to do. So, Ms. Davis, obviously it is a violation of your bond conditions to use any illegal substances, right? And so you tested positive for cocaine and methamphetamine on that drug patch, in addition to in the past not having it on correctly, and you didn't do what I asked you to do or ordered you to do also here. So I'm going to raise your bond at this time for those violations to $100,000. You will keep your court-appointed attorney while you're in custody. They'll be out to see you, and we'll just see what we do with your case at that point. You can go back with the bailiff.
wow.
Ma'am, come on back again.
Oh, you want an example out of it? I see.
I'll make an example out of
I mean,
anybody.
I don't
Hang
see
on.
how you so.
You want to stand here?
You don't.
You want to stand here and be disrespectful?
No,
I
just
will
want
make
you
an
to
example.
understand my situation. Like
I don't care what your
I'm not making
situation.
no excuses.
Okay.
I take accountability.
Right. So you tested positive for methamphetamine and cocaine.
I don't know how the patch work, ma'am. I haven't been doing any drugs.
Well, you did something.
I don't know if that's like the patch pick up sweat. I don't know if that's like after the process or what, but I haven't been doing anything.
All right. Go back with the bailiff. Good morning, sir. You're John Richard.
Yes, ma'am.
And Mr. Richard, is it Richard or Richard?
It's Richard.
And Mr. Richard, this is your initial appearance. And cause number 25, ECCR 0786. You are charged with, get it pulled up. The third-degree felony offense of failure to comply with sex offender registration requirements from April 30th of 2025. And since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am, I haven't. This was all just a misunderstanding. My sister had reported me missing.
Well,
But
and so they've indicted you for it, so it's probably really important that you get a lawyer, okay?
Yes, ma'am.
So that if there is some issues or some information that lawyer can get to the assistant district attorney that would work out your case, then that's how that kind of works out, okay?
Yes, ma'am.
So what I'll do is reset your case about 30 days to give you some time to try to hire a lawyer. If you-
I can't afford a lawyer because I don't work and I'm trying to get my disability and stuff.
Okay, but you do not have disability yet?
No, ma'am, I don't.
Okay, so why aren't you working at this point?
Because I can't.
Why?
Physically, my knees are bad and I have arthritis and pancreas and.
There's lots of jobs for people who don't need to use their knees or different things like that, right? Do you have a lawyer helping you with your,
No, ma'am, I don't.
so have you actually applied for disability yet?
Yes, ma'am, I have, but I've been turned down.
Okay, so if you've been turned down, then I'm gonna expect you to at least try to hire a lawyer. Okay, so let's go through, figure out if you can get one before that next court date. If you get someone hired before the next court date, then just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying and we'll discuss your options.
Yes, ma'am.
Also, in the meantime, I expect you to try to find work. All right, there's plenty of jobs out there that are not physical, that you could work with arthritis. There's people who work with that and have much more disabilities and still get out there and do something to make some money. So I want you to bring me a list of or proof of what you've done to try to find a job as well. Okay. Step in front of the clerk. She'll give you that reset notice.
Thank you.
Good morning. You're Jamaica August.
Yes.
Miss August, did you get someone hired?
No, but I did talk to the lawyers.
Who'd you talk to? Speak up.
Right, Kimber, Ryan Garcia, he's pretty fine.
Okay. So where are you on being able to get someone hired?
I did some 40.
Are you working?
Oh, no, no. I just currently lost my job like a week ago, but I'm looking for a job to be on the instant.
So you've been drinking alcohol? Why would you be doing that if you're on probation and you're not supposed to be?
Yes, ma'am. It was, I slipped on it, but everything took a sip or something.
You slipped up and weren't thinking. You've been on probation for a long time,
Yes, ma'am.
right? And now you've got a motion to revoke your probation. And I let you out on bond.
Right. Because I did that.
Have a seat in the jury box while I think about this. Is there any way to get, good morning, you're Joan Kraus?
Yes, ma'am.
And Ms. Kraus, were you able to get a lawyer hired?
Ma'am,
Were you able to get a lawyer hired?
no, but I was planning on it. I didn't know if y'all wanted me to use my court-appointed one or I didn't know how that worked.
So have you been to court yet in front of me? It's
Yeah, yes, but y'all told me to get 3 lawyers on.
right. So when you were here last, I said, if you could hire a lawyer, get one hired. And if you were unable to, then to visit with at least 3. Did you do that?
Yes, ma'am.
So are you going to be able to afford, are you working?
I'm retired.
So if you're unable to afford an attorney, I can have you fill out some paperwork to see if you qualify for a court appointed lawyer. Do you want to do that or do you want to try to hire someone? Can you afford to hire an attorney?
Yes.
Okay, so I'm going to reset your case one more time. You need to get a lawyer hired before that next court date.
Okay.
Okay, if you'll come over in front of the clerk, she'll give you your reset notice. Good morning, sir. You Richard Volry? And Mr. Volry, were you able to get someone hired? All right, did you talk to some lawyers?
So,
Who'd you talk to?
Brittany Holmes, James Martin Bacon,
Mhm.
Mr. Getz,
Gertz, mhm.
Benjamin Jeffries,
Say the last one.
Jeffries,
Uh-huh.
Thomas Kelly, and Mr. Roebuck.
Okay, And-
Yeah, they signed on the bank.
perfect. Thank you so much for doing what I asked you to do. Where are you on being able to maybe get someone hired?
What do you mean I'm unable to because I'm on disability? So-
You are on and you receive disability. How much do you receive? Okay, so I'm going to find that you qualify for a court-appointed lawyer. Thank you for bringing that paperwork with you. If you'll step in front of the clerk, she will let you know who that lawyer is and give you your instructions on contacting them, okay? Thank you, sir. Step right over here. Good morning, ma'am. Are you Tiona Hughes? And Ms. Hughes, did you get someone hired?
This Thursday I will, but I did speak with the
Speak up, please.
This Thursday I will, but I have contacted three.
Okay, who are you gonna hire? You're gonna hire somebody this week?
Yeah, Thursday, I'm just waiting. Tomorrow, getting
Okay.
balance.
So what I'll do, thank you, Ms. Hughes, what I'll do is I'll do maybe like a 2-week reset.
Okay.
That should give you time to get him hired
Yes, ma'am.
and then he can file the appropriate paperwork. If you get him hired, he'll tell you when that next court date is.
Okay.
Otherwise, I'm gonna give you a reset today so that if anything happens and you're unable to hire him for some reason within that time frame, make sure you're back on that day to
Yes.
let me know what's going on,
Yes.
right? 2 weeks, she's gonna hire Mr. Burbank. Thank you, ma'am. Morning, you're Mark Ramirez?
Yes, ma'am.
And Mr. Ramirez, did you get someone hired?
No, Mayor, but I got those names, and I have Charlie Ramos is hired right now for another case, but we talked to. So I talked to Dustin Galmore, and we all appointed me.
Speak up, please.
I appointed Mr. Alex Parker, and I talked to Brittany Holmes.
Okay.
Just now.
So are you wanting to hire Mr. Rojas because you have him on something else, or are you going to be?
Well, we're going to talk about to see how we're going to proceed with the case, whenever, knowing that the non-affidavits has already been signed for the prosecution.
Right?
So we're going to see how we're going to proceed from there.
So are you going to hire him to take care of this case then?
I now would have to see how much my money coming in, we'll see how it would work out.
Are you working?
Yes, ma'am, I work for the local 479 Reason Hall, Alabama.
Okay, so you need to get Mr. Rojas or someone hired before that next court date so that they can get with the district attorney.
Yes.
Sometimes when someone files an affidavit of non-prosecution, it takes care of the case. Sometimes it does not. It just depends on the case and the district attorneys, how they feel about that. So you still need to get an attorney hired.
Yes, ma'am.
And so you need to do that before that next court date, okay? All right, step in front of the clerk.
Okay.
Good morning, sir. You're Brandell Griffin. And Mr. Griffin, did you get someone hired?
No, the last time I came, you told me I didn't qualify. I tried 6 lawyers, different lawyers. I couldn't afford them.
Who'd you talk to?
I gave you all the names. of those two.
But since last time, who'd you talk to?
I went back to the same ones, just trying to.
Why would you go
Yeah.
back to the same ones if you couldn't afford them
I
before?
talked to 7 lawyers, like, they all around the same price, 5,000 more. I can't afford that, though. I didn't find anything lower than that.
Yeah, I mean, you filled out the affidavit and by law, you do not qualify. So
I'm trying to ask why is that because.
well, because your total income is $6,800 a month and your expenses that you put here are $2,260, which according to this means you have $4,600 left every month.
I told Anthony it was nowhere near 60.
You filled this out. I did it. And you swore under oath that it was true.
What did I sign? I get paid about 2,000 a month, and I pay child support. I have 7 kids. I pay child support for.
You put 0 on child support.
I put 0 on child support.
Well, no, you put that you pay child support for it. Yeah. That's all on here.
Yeah, I'm not understanding how it gets to 6,000.
I'm reading what you wrote. Unless I miss,
Unless I misunderstood some of the things on there or something. Like I can bring checks to bank accounts, all that. I can do all that. I can't.
hold on, I'm printing it out.
I was ready to finish this case and like I have evidence the girl to indicate.
I don't need to get it. I can't talk to you about that, but see, tell me. I mean, do you see the total on the left-hand column? The
Yes,
left,
because under assets, it has a car. My car is
the
worth-
other side, where you say your income
Total
is
income.
$6,800.
See that, but I added up assets, which is my car, and I had it worth around $6,000 or something. So I just added that number to that. Like I said, I must have did something wrong. I don't know. But
So
I
you
added,
make how much a week?
make like 18 an hour. I get paid bi-weekly. My check be like 1,200, 1,300.
Bi-weekly about 12 or 1,300. So total monthly is about 24. Okay. All right, so then based on that, you do qualify for a court-appointed lawyer. So I'm going to make that notation on here. You want to know, you may have them sit down. Step in front of the clerk. She'll let you know who your attorney is going to be and give you some more instruction. Good morning, sir. Are you Brad Thibodeau?
Yes, ma'am.
And this is your initial appearance, Mr. Thibodeau, in clause number 25 DCCR 0542. You're charged with the state jail felony offense of criminal mischief, impersonating public service from March 18th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Not impersonating, impairing or interrupting public communications, excuse me.
No.
Okay, so what I'll do, Mr. Thibodeau, is I'm going to reset your case for about 30 days or so to give you some time to try to get someone hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers you've talked to, so I know you're trying, then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? If you step in front of the clerk over here, she'll give you that reset notice. Good morning, sir. Are you Jimmy Couch?
Yes, ma'am.
And Mr. Couch, had you, the bondsman, you're on a bond in a misdemeanor case. It looks like on that violation of a protective order.
Yes, ma'am.
And you were, so for the record, you were arrested. It looks like January 29th of this year,
Mhm.
26, on a burglary of a habitation case. Just listen. You were arrested for that, right?
Well, I'm really not sure what I was arrested for.
Okay.
My
well,
ex-wife.
hang on.
Okay.
So you were arrested for burglary of a habitation and interference with emergency request for service. And the magistrate gave you a $25,000 personal bond and just let you were just released from custody.
Yes, ma'am.
After that date, on February 14th of 2026, you were arrested again, and that one for violation of a protective order.
Okay.
You made bond on that case and you were given a $2,000 bond on that case. All of this information has been brought to my attention, and I am at this time, I've got Mr. Rojas has been appointed to represent you, and Ms. Malfino is here on behalf of the district attorney's office. Based on the fact that you were arrested for a violation of a protective order after you were let out without a bond really on the burglary of a habitation, I'm going to find that you're at large without proper bond on the burglary of a habitation case, which is cause number 26 DCCR 0328. I'm going to set that bond at this time at $50,000.
Oh, my goodness.
There will be a condition of that bond that you have absolutely no contact or communication with.
Allison
What's the last name?
Couch.
So that means in person. That means obviously communication or in person.
Yes, ma'am.
And if you will also be required as a condition of that bond, if you make it, to wear a GPS monitoring device at all times. Do you understand?
Yes, ma'am.
All right, go back with the bailiff. You
This
go back
is-
with the bailiff. Visit with Mr. Rojas.
Okay.
Good morning, Mr. Coleman. I say good morning. I didn't hear you. All right, sir, are you Cameron LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered a plea of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, we have, Judge.
State has, Judge.
Any additions or corrections?
Additions and corrections.
Not from the state, we just asked you to follow the agreement of the parties, Judge.
Thank you, Mr. Coleman. Mr. LeBlanc, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a felony conviction on the record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and go to prison for between 2 years and up to 10 years. Do you understand?
Yes.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over all of your paperwork.
Yes.
All right, good luck to you, sir. Thank you.
Thank you.
See, Mr. Comerford, on J.C. Dunn, is this, good morning, sir. Are you J.C. Dunn? Or Jace Dunn, sorry. And Mr. Dunn was previously in court, entered a plea of guilty to solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes.
Any additions or corrections?
No, you're.
All right, then at this time, Mr. Dunn, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings, place you on probation for 3 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed. You will never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes.
I am handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You also just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Thank you. That's for him.
Oh.
Yes, sir.
There you go.
And then you've also got a sentencing on Ronnie Oliphant.
Yeah.
Good morning, sir. You're Ronnie Oliphant. And this is 25 DCCR 0379. Mr. Oliphant was previously in court, entered a plea of guilty to the third-degree felony offense of injury to a child. I've received that pre-sentence report, and has everyone had an opportunity to review that report?
Yes, Your Honor.
State has, Judge.
Any additions or corrections?
Judge, just based off the statements and some discussions with Mr. Oliphant, we would ask to withdraw his plea. I understand it's up to your discretion.
So, Mr. Oliphant, obviously, I have some notations here. I know exactly what your attorney, Mr. Comerford's talking about. You denied the offense that you committed the offense in this pre-sentence report. But here's the thing. If I allow you to withdraw your plea today, which I don't have to do because you pled guilty after having sworn under oath that you were going to tell the truth the other day when you were here for your plea. If I allow you to withdraw your plea today, there will be no plea bargains whatsoever accepted. If you want to go to a jury and let them decide, then that's your right. If you didn't do it, then it's going to be up to a jury. We're not going to get down the road a few months and a jury's here waiting outside and all of a sudden you're like, I really did do it. I'll take that probation or whatever it is. If we do this today, I am making a notation. Mr. Coleman, I'm sure will notate it on his file. Mr. Comerford understands and has been here enough to know that when I say it this way, I mean it. So do you want to withdraw your plea and go to trial?
Yes, ma'am.
All right, then we'll do that and we'll set it on the next available trial docket. Mr. Comerford will.
Just docket wise, the next 2 weeks, I've got a suppression hearing one day, following week.
Oh, no. The trial docket will be, you're probably about 3 months out for the
Okay.
next trial
3
docket.
months, okay.
Make sure if you have it, that kind of gets us close to in the middle of summer and stuff. So if you
Sure.
have any vacation, make sure you get that vacation letter in.
Yes, ma'am.
Look at that. I say Ms. Holmes will look at that before that's it. So if there's any vacation, otherwise it'll get set on the next one, which is about 3 months out.
Okay.
Okay.
Thank you.
All right. Stay in touch with your attorney. He'll let you know when you need to be back. Nah, I wrote it on here. Mr. Galmore? Mr. Gertz? Ms. Holmes? You have Dylan Wilkinson? Good morning. Morning, Mr. Nichols.
Morning, Your Honor.
Good morning, sir. Are you Dylan Wilkinson?
Yes, ma'am.
And this is 25 DCCR 0260. Mr. Wilkinson is charged with deadly conduct, discharging a firearm, and what is the announcement?
Judge, can we call a name this morning?
Yeah, sure.
Samantha Grant.
Can we get, oh, I think she has something going on back there.
Just kidding.
Let me get her back. Say it again, Samantha.
Samantha Grant. Yes, Your Honor.
Would you call the name Samantha Grant, please? Samantha Grant.
No response, Joe?
Your Honor, this case is about a year and a half old, and during that time, I've had no responses to written or telephone communication sent to the complainant. Without any reason to believe she is pursuing the prosecution of this case, state's going to dismiss.
All right, I'll sign that dismissal this morning. Mr. Boyd, that means your case is over. Obviously, if any, I'm sorry, not Mr. Boyd. Where am I? Mr. Wilkinson. Whatever went on, if anything, between you and Miss Grant, I don't know if y'all are still together or what's going on, but obviously you need to make sure and avoid any type of contact, probable with her or anything like that. You understand?
Of course.
All right, you're free to go, sir.
Thank you.
Mr. Jeffries, you have David Boyd. Good morning.
Good morning.
David. Good morning. Are you David Boyd?
Yes, ma'am.
And Mr. Boyd's case is set for trial to begin with jury selection next Monday afternoon, charged with deadly conduct, discharging a firearm in cause number 25 DCCR 0720. And what is the announcement?
We're ready with the exception of I am also on a trial docket in Polk County with an individual who's in custody. And he's at the top of the list over there. So
Okay. I'll take that. Is the state ready?
State's ready, Judge.
I'll take that into consideration. We do have a couple of much older cases here also, and so if for some reason it starts looking tomorrow, like you may end up closer, then we'll discuss that a little further.
yes,
Mr. Boyd, stay in touch with Mr. Jeffries. He'll let you know, if your case is going to be numbered for trial and what number it is and when you can be back next week. Okay.
yes, ma'am.
All right. You're free to go. Thank you.
Thank you, Your Honor.
And then Stephen Gomez. And this is the, yeah.
Stephen Gomez.
Good morning. You see Mr. Gomez this morning?
He is something.
Good morning. Are you Stephen Gomez? This is cause number 21-37252. Mr. Gomez is on probation for driving while intoxicated, third or more. I received a memorandum from probation asking for a judicial review. Let's see, remind myself. Looks like you've went through the safety program and had the scram and an ignition interlock device. The scram was removed after safety. And you were ordered to JCDI for aftercare. Oh, I know. Well, after continuously testing positive for illegal substances on your drug patch, you received sanctions, testing positive for alcohol, and testing positive on your drug patch. You've now been in the program 9 months, but your most recent drug patch again tested positive for methamphetamine. Turned in a hair follicle. Okay. Have a seat in the jury box. Let's get a test done this morning and then we'll talk about it a little bit more.
Absolutely.
Okay.
Step next week.
Yes, sure. This will take a few minutes. Mr. Kelly? Mr. Kimler, you've got LaAsia Clemens. Do y'all have a
Sure.
refusal on the tablet?
Emotion. Or emotion. She was a small child. I was inquiring, she was nursing. As a small child. Infant with her.
All right, are you LaAsia Clemens?
No.
And Ms. Clemens, in clause number 25, DCCR 1339, you're charged with the second-degree felony offense of robbery from September 9th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation and a $1,000 fine. You've got every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
So yes.
Yes or
Yes,
no?
ma'am.
And is there any reason, I mean, obviously that offer is with a deferred probation, any reason to believe that that would change?
To my knowledge, Judge, Mr. Kimler has yet to review the video. So.
I understand the facts from her, what happened. She was charged as a party to the offense. There was a chemical agent employed by the co-actor in the course of attempted theft.
Okay.
She was no part of it.
So I want to make sure you understand, Miss Clemens, that after today, I will not accept this plea agreement. So if you want to go to trial, then that's what we'll do. We're not going to say later, oh, there's something that Mr. Kimler has or hasn't seen, and that's going to change. If I put it on the trial docket, it'll be a trial. Or if you change your mind and want to enter a plea of guilty, it would either be open to the court or just something different and not as good as this 5-year deferred probation. Do you understand? All right, then we'll set it on the trial docket. Mr. Kimler will begin preparation for trial.
Your Honor, did I hear the court correctly that the court would not give her, it would be worse than 5 years in an open plea? Worse than
No,
5
that
years?
she would not be, this 5-year deferred probation would not be on the table at that time.
I thought I maybe misheard that the court said it would be worse than 5 years. She didn't accept it.
Not worse than 5 years in prison.
Oh, 5, I meant more than
But she's
5
not,
years.
this deal will not be on the table. So if you change your mind later, it'll be either open to the court or to something different, but not this deal. And if it's not this deal, it's also not going to be less than this deal. So I'm not going to accept y'all coming in here a day of trial and say, well, we'll take a 3-year deferred instead of a 5-year deferred.
Okay,
Does that make sense?
that's what I think it should be from whatever the punishment range is, what's available to the court, and it not be prejudiced by.
That's not what I'm going to do. That's
Okay.
if y'all make a negotiation and want to come in and plea. If you plea open to me, it's anywhere in the punishment range.
Which
If y'all change your mind, then, and you want to enter some negotiated deal, I'm not going to accept this again.
if the court still in an open plea could go less than 5 deferred, would consider something less than 5
I'll consider
years.
the entire punishment range as I'm legally obligated to do. All right. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when you need to be back and ready for trial. Ready to go. Ma'am, also, you need to wear not tights or leggings next time you're in court. That's not appropriate.
Okay.
Rafael Glover, Mr. Kimler.
The state's made another offer on this just now, and I wanted to run it by him before.
I'll hold it. And then what about Johnny Polanco Senior?
They're gonna reset, they just got the new case.
Mr. Smith, hold on.
John.
Johnny Polanco.
Your hands up.
All right, so you're Johnny Polanco.
Yes, ma'am.
And in cause number 24, DCCR 2168, Mr. Polanco is charged with aggravated robbery. I know we'd been waiting on a case.
It was brought over last week, but it was after review. It was too late to get it on for the grand jury. So
Okay.
one more, we said we should have it indicted, Judge.
Okay, perfect.
He's gonna need to post a bond.
So I'll just do a normal reset. Mr. Polanco, stay in touch with Mr. Kimler. Obviously, when that case gets indicted, I don't know if you've already made bond on it when you were arrested or not. If not, there will be a warrant. You'll need to turn yourself in, bond on that one if you can, and then we'll see where we are the next court date. All right, you're free to go, sir.
Stay in touch with Thomas.
And then you've got Jose Lopez.
I need an interpreter today, but I will for trial.
Are you Jose Torres Lopez? And Mr. Torres Lopez is charged with solicitation of prostitution, set for trial to begin with jury selection next week. What is the announcement?
Ready?
State is ready, Your Honor.
So, Mr. Kimler, if a client needs an interpreter, if you need an interpreter for him, you're hired. Typically, that would be something that you or he would provide. If not, he needs to file an affidavit quickly of indigence in order to, or a motion.
I'll have an interpreter. I know, that's fine.
Okay. I mean, and if he can't afford it, then file a motion with that affidavit attached to it. But we need to know that once I number the case.
I think I could file that in good faith, Your Honor. So, well, I'll have him.
Okay, then I will number the case tomorrow after the docket. Mr. Torres Lopez, stay in touch with Mr. Kimler. He will let you know tomorrow the trial order and what time you need to be back and when on next Monday.
Talk to Marie. We'll call. Friday.
Mr. Kevin Lane on Sean Dage Jr.
He's present.
Good morning.
Good morning.
Good morning, sir. Are you Sean Dage Jr.? And this is 24 DCCR 2353. Mr. Dage is charged with evading arrest or detention with previous convictions. And what is the announcement?
Your Honor, if we could just have 30 more days for an announcement. We've gotten an offer, we've gotten written discovery, but we want to get the video discovery.
Okay, and it looks like you were just hired in January, is that correct? Okay, any issues? All right, I'll just do a normal reset. Mr. Dage, make sure you stay in touch with Mr. Lane so that when he gets all of that information, including any video, you can go visit with him, watch that, and then we'll get an announcement at the next court date. All right, you're free to go. And Mr. Lane, you also have Ahmad LeBlanc.
Mr. President, Your Honor. We have an open plea, due to all counts in the motion.
But no agreement.
No, Your Honor.
Okay. Get that. Good morning. Are you Ahmad LeBlanc?
Yes, Your Honor.
Mr. LeBlanc, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You can put your name on. And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. LeBlanc, in cause number 21-36444, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 19th of 2021 for aggravated assault, a second-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
It alleges that you violated your probation. Count 1 alleges that you committed a new offense of possession of a controlled substance, penalty group 2, September 1st of 2025 in Chambers County, Texas. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample August 3rd of 2022 that tested positive for marijuana. Is that true or not true? And then count 3 alleges that you're behind in your court assessed fees as of December 10th of 2025 in the amount of $480. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
True.
Did you plead true to those counts because they're all actually true?
Yes, Your Honor.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case for sentencing so that we can get an updated pre-sentence report. And then we'll go forward with sentencing. Before I let you go today, however, I'm going to get a drug test here in court. I want you to have a seat in the jury box and let's get that drug test done.
He does have a drug patch.
Okay, thanks. So boy, he needs to be printed.
Yeah, is it unagreed?
It's unagreed, yes, ma'am. Mr. Lewis,
Yes,
you've got Janisha Jackson.
Yes, ma'am.
Good morning. Good morning, ma'am. You're Janisha Jackson.
Yes, ma'am.
And this is 25 DCCR 0903. Ms. Jackson is charged with abandoning or endangering a child. And what is the announcement?
Your Honor, if I may, before we get to an announcement.
Sure.
Something on this indictment should be cleared up. In reviewing for the docket this morning, it's come to my attention that the body of the indictment, which is controlling, is correct. It alleges endangering a child. The style of the document is incorrect. The allegation under E is abandonment without the intent to return, and that is a second-degree felony. However, what Ms. Jackson is actually being charged with in the body of the indictment is 22.041C, and that's a state jail felony. So Mr. Lewis and I have discussed that this morning and on Friday as well.
Any objection to me making that modification to the style?
No, no.
I'll get that done so I have it correct. Give me just a second if I can do this. It's 22041C.
Correct, Your Honor.
Sorry. Okay, got that modified on the indictment. And so then what is the announcement?
Judge, we've talked about potential resolution on this matter, especially with that the amendment we discussed. If I can get it maybe a week or two with Ms. Jackson, so I can explain that to her and the ramifications of that, we'll be able to get it finished.
All right, we'll do about a 2-week reset. Ms. Jackson, make sure you call Mr. Lewis, make an appointment, go visit with him so that when you come back, we'll get an announcement, figure out which direction we're going to head on the case. Okay. All right, ready to go. Thank you.
Thank you, Judge.
Thank you, Ms. French. And then Mr. Okay, I'm signing that dismissal in Clifford Norman's case.
Yes, ma'am.
Mr. Parker, you've got a sentencing on Samuel Cadena. What is this? Oh, there's a new, that's what. It is, yeah.
Window tint,
Huh?
window tint.
Okay, so y'all
Not-
already know that there's a warrant, that doesn't have
I made
anything to
it-
do with this case, correct?
Yeah.
Okay. Good morning, sir. You're Samuel Cadena?
Yes, Your Honor.
And Mr. Cadena was previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. And I've received that pre-sentence report. Have you all had an opportunity to review that report?
Yeah, Your Honor.
Yes, Your Honor.
Any additions or corrections?
Nothing more of, Judge.
Not from the state.
And Mr. Parker, are you appointed or hired?
Hired.
Okay. All right. So, Mr. Cadena, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the fine of $500 and to follow all of the rules and conditions of probation. In addition to all of the rules and conditions that probation typically has, I am going to order that you are not allowed to consume any alcohol, and that for some amount of time you will be required to either wear a scram device or use a handheld device, whichever probation feels is appropriate. You can talk to them about the benefits of one or the other. I don't care which one, but you will have to have one of those devices. Obviously, if you test positive, it's a violation of your probation for alcohol. If you don't follow any of the other rules on probation, they're violations as well. This is an excellent opportunity because you don't have a felony conviction on the record. And if you successfully complete the probation at the end, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation. If you don't show up, and more specifically and concerning to me is if you test positive for alcohol at any time, then you will be back here in court. You can be found guilty of the offense and you could be facing a sentence of anywhere between 6 months and up to 2 years. Do you understand?
Yes, Your Honor.
If you have any issues with alcohol and not using alcohol, talk to probation. There is help that they can give you, but you need to ask for that up front, because if you test positive and then say, oh, now I need help, it might be too late and you could end up being revoked. Do you understand?
Yes, Your Honor.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you before you go today. You will have to go with the bailiff because of that warrant, but she'll visit with you about what to do as soon as you're released from custody, okay? Good luck to you, sir. You can go back with the bailiff.
This docket highlights a courtroom focused on accountability, compliance, and procedural discipline. The primary legal conflict centers on defendants failing to meet bond and probation conditions, alongside delays in securing legal representation. The judge maintains a firm, methodical stance, emphasizing personal responsibility, strict adherence to court orders, and zero tolerance for noncompliance. Key moments include Brittany Davis, bond increase after positive drug tests and failure to follow instructions, illustrating the court's swift response to violations. Across multiple defendants, a pattern emerges: incomplete effort in hiring counsel, lack of documentation, and inconsistent explanations. In contrast, those who followed instructions received consideration or court-appointed representation. The judge consistently reinforces consequences while offering structured opportunities for compliance. From probation warnings to plea decisions, the courtroom underscores a clear message: cooperation and accountability directly shape outcomes, while disregard leads to immediate and often severe repercussions. Thanks for watching.